Great.
Good day. My name is Anselm Kamperman-Sanders. I'm a professor of intellectual property law at Maastricht University in the Netherlands. And during this session, I will discuss with Mr. Jeremy Finichel the changes to the French Patent Act based on Loi Pacte. Jeremy Finichel is the head of the patent department at INPI in Paris, the Institut National de Propriété Industrielle. Jeremy, I will ask you to explain to us a little bit about the reasons behind Loi Pacte and the changes that it will bring about in the French patent law. And of course, we are very interested to hear from you what prompted these changes and what also national policy is behind these changes. Which interest groups have pushed for this legislative change and what the early experiences are with the Loi Pacte. Please, Jeremy, you have the floor.
Thank you very much. Dames and heren, that are the only words I know in Dutch. At first, I thank very much Mr. Dalkian Dalgro, director of the Dutch Patent Office, and Mr. Mark Berg, having given the opportunity to the French Patent Office to give some feedback, impression, and information on the way my office, the French Ministry of Economy, and IP stakeholders discussed and succeeded in putting in place the IP change included in the Pacte Act. 20 years ago, when I joined INPI as an electronic and computer patent examiner, I would not have imagined that I will have one day the opportunity as the chief of the French patent department to be responsible for implementing all these changes. It was and it is still now a challenge for my teams, and we will do our best to succeed in implementing our French government when our French government decided to modernize French IP patent procedure. The Pacte law is a law initiated by the Ministry of Economy. The INPI is placed under the supervision of this ministry. This law is not specific to IP, but concerns a whole set of provisions that the government has wished to implement to boost growth, in particular the growth of French SMEs. The elaboration of the text began late 2017 with a consultation phase, which ended on February 5, 2018. The fact that the government has considered in its first consultation introducing IP provisions into parliamentary debate, including the issue of modernizing patent procedures, shows to what extent it is now recognized that IP is essential in the states of economy. That provisions made in 1968 last significant change to IP regulation were no longer necessarily in the line with the needs of today's business. Here are some figures and information that contribute to the thought on the opportunity of setting up the refusal for lack of inventive step, the creation of an opposition procedure, and the creation of a provisional patent application. As you can remark, only 20% of patent applications are filled by SMEs and mid-caps, while 60% of patent applications are filled by large French groups. French SMEs file 4 times fewer patent applications than German SMEs. However, SMEs and micro-enterprises in France account for 99% of registered enterprise, employ half of employees, generate 1/3 of the total turnover of all enterprise, and carry out more than 2/3 of the research and development activities in-house. Faced with this observation, and in order to strengthen the creation and development of enterprise, the Minister of Economy and Finance, Mr. Bruno Le Maire, launched proposal to modernize and adapt patent procedure to SMEs' needs. The debates at the time of the decision to implement the Pacte law mainly focused on the fact that the 30 biggest using companies in France using the patent system might have thought that the new provisions were not advantageous for them and that Pacte law was only useful for SMEs. Go back. What are the company's expectations related to IP rights? French companies must be able to stand out from their competitors due to their capacity to create value through innovation. Their main expectations in terms of the industrial property were legal certainty and strength of their IP rights on a national and international scale, namely for counterfeiting purposes. Is it really possible to use your patent for counterfeiting purpose if you have a doubt of the inventiveness of your patent? Greater confidence in IP procedures. More and more people are now against patents. Patents of low quality do not benefit IP users. It is the role of the office to minimize non-real patents and the role of third parties to appreciate the trueness of the patents. Increased possibilities of funding and cooperations. How to obtain fundings when investors have doubts on the patent quality. Access the system consisting of a gradual offering that corresponds to the life cycles of companies in their market. The applicant should be able to adapt his strategy, application, extension, counterfeiting action, partnership based on patent in accordance with the information available to him through the whole patent procedure. The first measure implemented by the Pacte law was patent opposition procedure. The opposition is with the provisional application the first proposal of the Pacte law. It was aimed to give the opportunity to a third party to easily activate a process to sanction a granted patent by the MP while not inventive and at a low cost. Tax of €650. No monetary representation, quick result in less than 50 months. I mentioned poor quality patent because in its first proposal, Pacte Act didn't introduce the possibility to patent examiner to withdraw a patent application for lack of inventiveness. Consequently, the opposition procedure possible since the 1st of April 2020 has been launched before the inventiveness examination during granting procedure exists. It is impossible to challenge patents for which no sanction has been taken grading inventiveness when granted. More precisely, the patent opposition procedures enable third parties to oppose the patent within a maximum period of 9 months after it had been granted, make it possible to challenge the validity of the patent directly before the French Patent Office. Advantages: a quicker and less expensive procedure than legal proceedings, and challenge poor quality patents at lower cost. All validity criteria can be mentioned during opposition procedure. The main obstacle we encountered during the discussion with the stakeholders were the patent department, the main difficulties were some big applicants were afraid that SMEs will systematically use this procedure for their patents with a low level of inventiveness. Will MP be able to appreciate inventiveness, sufficient of description, extension of the object of the protection, and so on? Big applicants are more, but the reality is that big applicants are more often in the role of opposant than applicant. Opposition procedure will benefit also big applicant, French enterprise, if foreign patent applications are directly applied in France in the future. Some French big applicants observe that it would be useful not having national opposition procedures to be efficient at their European competitors, namely during EP opposition procedures. Inventiveness is already appreciated at MP during the granting procedure. Yes, it's the fact that a lot of patent attorneys are big companies assume that they do not really are comfortable with opposition compared to German patent attorney, for instance. The second big issue with the Pacte law was the introduction of examination for inventive step. The measure allow a patent application to be refused due to lack of inventive steps. Extend the refusal condition, namely invention, novelty, and inventive. Advantages: strengthen the validity of the French patent, increase the value of the French patent, bring the French procedure into line with those of other national patent offices, like UK, Germany, Spain, and the European Patent Office. As you probably know, even if a French patent was not considered as valid if non-inventive, the last version of the French legislation, which was used until the introduction of Pacte law, change did not allow the French Patent Office to withdraw a patent on the inventiveness criteria, even if the patent examiner mentioned a lack of inventiveness in one of his communications during the granting procedure. Due to this situation, many prejudices have begun to be more and more present in the mind of patent professionals, foreign competitors, and even in business angels. The two main prejudices were none of the French patent was inventive and consequently were weak and have low value. French patent examiners were considered as formality agents and known as patent engineer with no real knowledge about. As for the introduction of opposition procedure, we also encounter some obstacles where we discuss of the possibility of inventiveness introduction. Some of big applicants consider that a two-level patent system based on national patents without inventiveness and an EPO extension with amended claims is more efficient and less expensive. Same question, will INPI be able to appreciate inventiveness? And a very, very important question, the number of French patent examiners will be insufficient. In reality, a lot of SMEs do not have international markets and are only interested in the strength and strong national patents, with no willingness to apply for an IP patents. Secondly, when you modify your set of claims for an extension, and it is very often the case for big applicants, it will not generate additional cost if you use this modification to go on with the national procedure. There is also a new interaction between a French national patent and the future unitary patents. I will explain it a little more. As you probably know, presently, when a European patent having the same set of claims than a French patent is granted, the French patent stops proceeding its effect. In the future, new French legislation related to the unitary patent will allow two patents, IP patent and French patent, processing their respective effects even if related to the same object. It's already the case in many European countries such as Germany. Consequently, If one day the unitary patent is implemented, it will be good for French companies to have two France patents, a national one and a European one. Concerning the number of patent examiners, as I mentioned before, the possibility to allow a patent application to be refused due to lack inventive step was not initially scheduled in the first version of the Pacte Act. It was mainly due to a previous study made in 2014 performed by the French Court auditors with two main results. It is very important to keep complementary between the French patent and the European patent, which both are valid in France. If the French Patent Office introduces an examination based on the inventiveness, the French Patent Office should increase the number of examiners in a huge manner, more than 100%. The reality is, even if we introduce the examination of inventive step, such report and written opinion will still be made by EPO, and the first and the inventiveness examination will perform thanks to the information included in these documents. We also internally at INPI made some analysis to estimate the real additional load due to inventiveness examination. The main results of our analysis were 10% of the French applications are nowadays withdrawn, namely for formalities reason, before research is performed. 20% of the French application obtain a search report which does not mention any document. For all these applications, there is no additional load if you introduce the possibility to refuse an application due to lacking competence. Furthermore, more than 50% of our applicants already modify their patent application to introduce technical characteristics and combine claims when they answer the search report. So, in reality, we do not need more than 20% additional examiner, but only 20% more examiner. And due to this reality, the Ministry of Economy was okay with introducing this new way of examining a patent. Next measure, a provisional patent application. As I mentioned before, the possibility to allow patent application, provisional patent application to, as I mentioned before, the provisional application was part of the first provisional pact law. The main idea was to make the patent system more attractive and accessible to SMEs, startups, and researchers. Combine economic strategy and grant proceeding. Measure. Propose an inexpensive procedure with fewer formalities. A period of 12 months to convert the provisional patent application into a patent application. Advantages: secure an early filing date to give applicants time to find funding, set up a development team, and decide on a protection strategy. File in any language, establish a proprietary right, no publication of the provisional patent application if not transformed into a patent application. The main obstacle we encountered during the discussion with the stakeholder were some big applicants were not really interested with the provisional patent application, and furthermore, many French patent attorneys find it very difficult to implement. But the reality is, even big applicants encounter emergency situations which need to secure date before technical deviation. And if the provisional application does not contain all the technical information to obtain a protection for your entire invention, why to be afraid by such a situation? It is possible to use the priority system as is currently used in actual patent extension procedure. Furthermore, SMEs need to secure their knowledge before entering a negotiation process and funding process. Here you can see the the timeline implementation of the Pact law. In January 2020, we launched the new ULT certificate, which now is available 10 years. Since the 1st April, it's possible to fill an opposition to a patent. The first positive receivability result has been published last Friday on the French official patent gazette. So we had our first opposition who was filed the 2nd of April. Next Friday, the 22nd of Monday, each new patent application can be withdrawn because lack of inventiveness. The 1st of July, it will be possible to apply for a French provisional patent application. As you can see on this slide, now the French patent legislation offers a complete patent toolbox which suits the different strategies of our companies, whatever you are, a large group, an SME, or a researcher. The 4 main ideas of this toolbox are that if you are not interested in a tool, this tool can suit a company which doesn't have the same size, the same market, or the same budget as you. If you are not presently interested in a tool, think about the future, namely the unitary patent and the possibility that more and more foreign competitors will maybe apply directly patent in France. The more tools you have, the more it will be possible to you to change your strategy if necessary, or differ your strategy depending on the type of innovation you are working on. Patent tools should be in line with the economic life cycle of the invention, from the idea to the market. So I hope with all these presentations, figures, and difficulties that I could explain the way we decided to implement all the new measures introduced by this Pact law. Thank you very much for your invitation, and thank you very much for your attention. So, Mr. Altem, you have now the screen, and you are free to ask me all the questions you want to complement this presentation.
Thank you very much, Mr. Finichel, for that very, very comprehensive overview of the changes to the French patent system on account of the Pacte Act. It strikes me that the French efforts are very much in line with redefining national industrial policy. But this also prompts a number of questions. Basically, to what extent do you feel that this is a form of regulatory competition, also in light of the unified patent package? It is clear that the intent is to boost the possibilities for French SMEs and industry as a whole for international filings. But to what extent does it then still make sense to have the additional French route available? As you also pointed out, you would like, ideally, perhaps, to have French industries engaged in a European or as a French. Isn't this a bit contradictory with the entire objective of the UPC itself?
Yes, you're right. I mean that we don't really know if in the next future the united patent will be really used by the French industry. That means that there are industry, very big enterprises, which are very interested in this unitary patent because they are, excuse me for the words, fed up with having the obligation to make some controversial actions in many different countries, and prefer in the future having only one controverting action. But on the same time, there is a lot of industries, namely chemical industry, which are not really comfortable with this situation. And at the first beginning of the unitary patent, we think that it would help the French industries having both a strong national patent and a strong European patent to decide if they will use unitary patents. Because of the possibility in the next future to have both national patent and European patent for the same claims, we think that it will ease to start with the unitary patent. I know it seems to be a little bit contradictory, but in reality, if you make people more confident with your national law, it will ease the use of European patent if in case of unitary patent. And second also issue, as I mentioned in my slide, as you can see, there is 60% of first application which are now extended to PCT, national foreign procedures, or European patent procedures. And a lot of big industries now use only the French national procedure to obtain a search report and a written opinion. And the fact that you introduce inventiveness in our procedure will not change the strategy and the way they will use in the future the national procedure. So, normally speaking, the introduction of inventiveness will make now possible for national industries who only have national markets having a strength patent, and for people wanted to extend their initial French application, having both the choice of having two very strong patents and be more comfortable with unitary patents.
What about the claims? What about the alignment of claims in relation to the national and the unitary patent? Should they be aligned, or are there different rules in place foreseen in relation to the French procedures of examination? I guess you stick to the problem solution approach and also the EPO's practice and case law, but to what extent is there room for national deviation, or do you indeed stick to sort of the EPO's line of reasoning and case law?
You're totally right. We will follow the solution problem approach as the UPO performed. And as I mentioned, we will try to perform our examination based on the search report result made by EPO. And as I also mentioned, we are sure in the next future that the answer given to our internal procedure by applicant will be approximately the same as the answer given to EPO. That means that there will be in the next future some kind of harmonization of the setup claims. I'm sure the claims will not be exactly the same. It's impossible, but we will try to have some harmonization set of claims. And if you just mentally plan a timeline for the French patent application, I mean that first you apply for the French patent application. You obtain a search report, with a written opinion. So, because of the results, you can decide to extend to for a European patent application. If you decide to extend, normally speaking, you will change the way of claiming your invention, and you will apply for the European patent application with a new set of claims. And as I mentioned, the new set of claims will also be used internally to answer the French search report. And because we will base our inventiveness examination based on the same analysis, that means that on the solution problem approach, normally speaking, we will the French patent examiner will have the same idea of the patentability of the European patent examiner. That means that through this way, normally speaking, both patents will have approximately the same claims at the end.
Yes, that's an interesting point. But nevertheless, with the entire opposition procedure also pointing to an administrative national procedure that then incorporates the European Patent Office's search reports, there will nevertheless be a need for judicial review, independent judicial review. I understand that this will still be the Court of Appeal in Paris, ultimately, in final instance. But does that then also mean perhaps that your presentation on the need for a mere 20% increase in patent examiners is a bit optimistic? After all, you have to cater for domestic legal procedures, and that also means that you have to assure independent review. And on top of that, how do you then foresee the composition of the teams that deal with the entire examination, inventive step, and opposition proceedings in the context of the number of additional examiners needed? Will they be the same examiners? Will the examiners be sort of having their feet in the clay and doing the practical work, and then being also referred to sort of opposition panels? And in view of the fact that there is this need for domestic administrative legal proceedings to be accurate, also legally sound, do you also foresee legal members to be part of these opposition boards, as is the case at the European Patent Office, after all?
Yes, you're perfectly right. Nowadays, and it will be also the same for opposition procedure, if one of the parties wishes to appeal against a decision of the director of the INPI, the appeal must be made to Paris Court of Appeal, which is the only court in France who deals with patent cases. Concerning the internal patent department organization, the patent department is organized into 10 examination clusters. Each examination center cluster is responsible for a limited number of techniques. Since December 2019, I decided to name in each board a patent engineer designated as the opposition referent. This engineer will be president of the opposition division in charge of the opposition against a patent whose techniques are those of its pool. The opposition will be held by the president, assisted by 2 patent engineers, and, as you mentioned, the possibility of a legal advisor, an internal INPI legal advisor. To ensure transparency, if the engineer, if the president of the division is an engineer who participated in the examination of the patents, so we will ask 2 change of the president. And the new president of the opposition division will be the referent of the poll, which is technically the closest in terms of technical mean.
Okay, thank you. Let us take a step back for a moment now, because this is very much the technical and organizational aspect. But let us return a bit to the reasons for the Pacte Act. And there you indicated in the beginning of your presentation that the quality of patents may have been a driver, the so-called non-real patents, as you called them.
Yes.
Did INPI, in fact, commission a study to the numbers of these types of patents and whether they were actually problematic? Were they maintained over time, hindering competition, or were they even asserted? In other words, how real is the problem?
Yes, your question is very, very interesting. As you mentioned, and a lot of discussion during the process told that it's not true that a French patent is a non-real patent. Maybe between 70 and 80% of French patent applications are new and inventive. But a lot of people do not consider a patent application for the contents of this patent application, but a lot of people just consider patent application, you know. And I have two stories. One story is the story of one of our present deputy, national deputy, who was very engaged for Pacte Act. He was at the head of a small SMEs in Alsace, and he decided to apply a patent. He applied a patent. He succeeded in having his patent granted, and maybe 3, 4, 5 years later, he saw that there were counterfactors on the French territories. So he decided to attack this counterfactor. And then he was very disappointed because few people believe in his patent just because it was a French patent. And he was advised not to attack counterfactors because he will certainly lose. Nobody really examined the content of the patent, and just because it was a French patent, they say you will lose your legal procedure. And there is another story coming from a very big companies in France. He told me, you know, I have some very regular conversation with American people, and we try to make some common invention process. We also are discussing very often on markets, and I make something. I make one day a proposal. I propose to have a negotiation based only on the French patent. And the American people say, no, we are not interested in the French patent because we know that the French patent has no value. He said, but how can you say that? I have exactly the same European patent with the same set of claims, and you are interested in having a negotiation with me based on this European patent, and you just mentioned that you are not interested in having a negotiation with me based on the national patent because you find it very bad level. That means that even as you mentioned, and you are right, even if 80% of the present patent French applications are new and inventive, nobody considered the patent with this new inventiveness. That means if nobody, investors, business angels, competitors, considers your national patent is not a very good tool for negotiations, innovations, and fundings.
I think that would seem still to be anecdotal, and although I don't want to sort of be too critical in relation to methodology and so on and so forth, if these anecdotes are also backed up by larger numbers, then I can see that this is very much an exercise in bolstering also the reputational value of the French patent. So are these two examples merely anecdotal, or do you actually have a larger study that demonstrates that the reputational value of French patents has hitherto been sort of suboptimal? So that's really what I'm asking. Is it part of a larger study?
It's part of a larger study, even if it's very difficult to speak about strategy with companies. It was also one of the difficulties with Patent Act implementation. That means that there was a lot of prejudice. And as I mentioned, a lot of people talking about general purpose. And it was very difficult to enter very precise discussions and to have very precise examples. But we did succeed in having real face-to-face exchange and having not only global aspect, but many of real stories, and we conclude with very efficient conclusion.
Okay, thank you. So how, if this is the underlying issue here, how do you square it with the utility certificate that is still part of the patent package? I also noted that grace period, as is available in Germany, was discussed as part of the utility certificate model in France, but was rejected. Can you enlighten us a bit about this issue?
At the beginning, some of people, namely the research and development, were very interested in having this delay of grace as it's possible in Germany, but actually we know that the French office is not really in favor on this possibility because it's very hard to implement. And I know that European Patent Office was not really in favor on this possibility, and we decided not to be against this global European position. So we prefer that people apply for a provisional patent application and be able to discuss on their invention because they really secure in a very very single way the invention in a provisional patent application.
Yes, this is where I thought we would end up with the provisional patent application. Now, here also perhaps a bit more critical question, because we know from international experience that the problem with provisional patent applications and sort of further filings or international filings lie with the issue of lack of adequate description, and therefore also issues with the non-provisional or normal priority application in relation to additional materials, which will then not be covered by the provisional patent application date. How do you envisage tackling this problem? That's one question. And another one is also then, are you not providing a false sense of security to especially SMEs who are sort of pushed in this direction? And finally, do you perhaps then also see a different role for INPI in terms of advising SMEs that a provisional patent application is definitely not the panacea to having an early priority date, but merely serves as you put it, a way of delaying later decisions. But nevertheless, it also points to the underlying problem that if the provisional patent application is not yet sort of fully in line with the ultimately crystallized version of the priority patent application, you are creating problems.
Yes, but as I mentioned before, the fact that national patent applications has not exactly the same technical characteristics in his description of European patent applications, which is based on the priority of the national patent application already exists. I mean, as a patent examiner, I know that from time to time, when I perform the self-report on the written opinion, I have two dates in mind. First date, which is related to the first application, and the second date for novelty and inventiveness purpose, coming from the date of the extended patent. So when we see a difficulty, normally speaking, difficulties already exist. So we will do a lot of awareness actions in France to SMEs, saying that if you apply for a provisional patent application, and if you want to transform this provisional patent application to a real patent, but you don't pay attention on additional matter, there will be some difficulties, and you will have in reality two dates for novelty and inventiveness. But it's not a bad idea having two dates. At least you have one date for novelty, which began with the date of your provisional patent application. So even if none of all technical characteristics are in your provisional patent application, you have a date for all the technical characteristics you apply in your provisional patent application. And you're totally right. We will advise SMEs to make internal priority if they see that there is a lot of additional technical characteristics between the day they applied for provisional patent application and the day they decide to go to a real patent. So you're right. The difficulty we have with the provisional patent application is awareness efficiency. And you're also right, and we hope that tomorrow we'll succeed in giving the right way to use the provisional patent application to SMEs. And I also agree with you, if we miss this right way to use provisional patent application, maybe that we will create some difficulties which are in contradiction with the way we thought the provisional patent application.
You see, to me, it sounds great technically, but as a lawyer, I simply see great opportunities for legal proceedings. So this is also very visible in those jurisdictions where provisional patent application are already possible. So can you shed some light in terms of the way in which, at least from the policy perspective, this issue has been addressed, or has it been considered even as an issue during the parliamentary debates? Or is it simply that, to put it very bluntly, the profession of patent attorneys thought that this was fine, and that it was simply an issue that went away or made its way through on account of certain lobby interests?
When I mentioned that the provisional patent application was present in the Pacte law initially, I don't mention that in the debate, because, as you mentioned, a lot of people were not interested in. In fact, Parliament decided that it was not necessary to implement this provisional patent application with a new law. It was not necessary to introduce this provisional patent application in Pacte law. We just changed a little bit the rules and not the law. Because as you mentioned, as you probably know, since the PLT introduced in 2008 the possibility of filing a patent application without claims, many users considered that it was not necessary to create a provisional request. However, when an applicant filed an incomplete application, he received immediately in communication from the INPI and risks a withdrawal of his application. At the same time, the French Patent Office does not have the power to judge whether it can delay the examination or not. So we decided together with patent attorney, also by query indicating that the applicant wishes a provisional application, the applicant is the master of his time, and the patent office can focus on patent applications requiring examination. And as you mentioned in your former questions, is 20% more patent examiners sufficient? If we don't prioritize our work every day in a very efficient manner and to spend time on the applications depending on the wishes of the applicant, certainly 20% will not be sufficient. But if we have the possibility to know that this application can be a little bit delayed because it's written, it's a provisional application, hey, don't pay attention to this application for procedural purpose because it's only provisional application. You know, we are not really decided on convert it into an application, and we will give you the answer. And as soon as decide that this provisional application become an application, it's time for a patent examiner to examine this application. And because we decided that it's very interesting that both patent examiner and SMEs are masters in their timeline for innovations, we maintain the idea of provisional patent application.
Thank you very much for that answer. I also have a question in relation to the provisional patent application and the option to search. I guess the provisional patent application will remain confidential for a period of time, but when will it be accessible to the public?
So there is, the search report will be made as soon as the patent decided to transform his provisional patent application to a normal patent application. and the publication of the technical description of the provisional patent application will be published only if the provisional patent application is transformed in a normal patent application, and it will be published 18 months after the date of the provisional patent application. Okay, but as you mentioned, we have some hesitation between the provisional patent application and the way of introducing a deferred examination. And we are not really satisfied with the deferred examination because we think that there is no equity between applicant and opponent with this system right now. Maybe we will have some more study, and maybe there will be a Pacte law in some year, introducing what we consider a complement to provisional patent application that is a deferred examination, would be offered the possibility to apply for a patent, having a self-report and saying that you are not interested in the complete examination procedure, and we will come back to the French Patent Office 1 year, 2 years, 3 years later, as it's common in 50% of patent office in the world, to go on with the examination. But as I mentioned, we are not yet very comfortable with this deferred examination, and we prepare to introduce first a provisional patent application.
That is quite a fundamental admission for a system that is new to the system. That is quite remarkable. Final question in relation to the interaction between the opposition procedure and the examination of inventive step. And here the simple question is opposition possible or even conceivable without the inventive step examination? You must have thought about the interconnect in this regard. It'd be nice if you could elaborate a bit on this issue.
As I mentioned, when we first discussed of the Patent Act, there was no the volunteer of introducing the inventiveness examination during patent procedure granting, because we introduced the opposition procedure first because we wanted competitors of national patent which were not really inventive to mention it at INPI, and don't need to go to a legal procedure which is very long, very expensive. So it is possible to make an opposition for inventiveness purpose, even if the patent was granted before the Pacte law. That means even if the patent was granted without the possibility to withdraw the inventiveness information. But as I mentioned before, and you know, there is still the prejudice in mind of all people. It's not because formally we grant a patent without the possibility to reject the patent if lack of inventiveness, that during the procedure there was no information related to inventiveness. As I mentioned before, we based the actual procedure and the procedure in the future will be based on the result of the self-report and the written opinion. And when you read the self-report, when you read the written opinion, you have plenty of information related to inventiveness. And furthermore, there are, if you read in the French registers, communications between the French patent examiners and the applicants, you will also see from time to time some communication saying, hey, we think your patent is not really inventive. That means that the applicant has already today all the information related to inventiveness. So he will not be surprised by the fact that there is an opposition on this patent, and maybe decided it was better for him not responding during the procedure, but then he will be forced to respond to both patent examiner and opposant if there is an opposition on this inventiveness.
Is there also in this light an issue of observations? Because typically this is something that third parties may advance to the patent office, but is really rare, as we know from EPO's practice, because this is basically helping the applicant. So is this also an issue that is foreseen in the Pacte Act?
The third observation already exists in the French patent procedure, but isn't really in the French patent procedure. Yes, okay, but in the French patent grant procedure, we only receive maybe between 10 and 20 third observations per year. And the difficulty we have with this observation in the granting procedure is that the observations are made on the such report results. That means that it's certainly too early for a third part to have a clear view of what will be the granted patent. That means that you make some observations on the first set of claims and not on the last set of claims. And during the opposition procedure, we decided not to allow such an observation from third parties. Only the opposants and the applicant, only the different opponents, because if there are more than one opposant, we will try to combine all the opposants in a same global opposant party, and we will go on with one global party and the applicant. But there will be no possibility for a third part to enter this procedure opposition.
It's clear, it's still an inter partes procedure.
Exactly.
Okay, thank you very much. I think that concludes this initial round of questions. I would very much like to thank you, Mr. Fenichel, for your time and your very, very clear explanation of the subject matter of the Pacte Act. And I look forward to further discussions and, of course, experiences and lessons learned from this transformation of French patent law. Thank you very much.
Thank you very much also for all these very precise questions, and I will try to give you some information in the future according to the result we obtained, and be free to send me some additional questions, and I will try to answer in a very transparent way because the most important is that if there is some mistakes in this patent new patent law, is that other countries doesn't pay the same mistake, and if there is some success, we will be very proud to share the success with you and help you to implement maybe a new law also in Netherlands.
Thank you very much.